My name is David Taylor. I'm an accredited specialist in employment and industrial law. I'm going to talk about the law concerning sexual harassment in the workplace. Sexual harassment is defined in the law broadly as being unwelcome conduct of a sexual nature. There are two crucial elements to that definition. The first is that the conduct needs to be of a sexual nature, and secondly, that it needs to be unwelcome. Conduct of a sexual nature doesn't mean someone necessarily trying to have a sexual relationship with a person, so showing someone pornography is certainly conduct of a sexual nature, but does have a sexual dimension to it. Similarly, the concept of unwelcomeness is really significant. Single one-off conduct is often not able to be said to be unwelcome because a person couldn't reasonably know. So, for example, asking someone on a date is generally not thought to be an unwelcome act, but repeatedly asking somebody to do something where there's been refusals is often an unwelcome act. In the event there's allegations of sexual harassment, a complaint can be filed under one of the number of legislative regimes that prohibit sexual harassment. Where a person wants to bring a claim alleging sexual harassment, they will generally file a complaint. The complaint can be under one of the number of legislative regimes that prohibit sexual harassment. In each case, the normal course is for a person to name both their employer and the person who was responsible for the harassment as respondents to the claim. The employer often has a defence if they can establish that they did everything reasonable to ensure that the harassment didn't occur. Once the claim has been commenced, it will be provided to the employer and generally to the person alleged to have engaged in the harassment. They'll be given an opportunity to respond. It's important to note that the interests of the employer and the harasser may not be the same, and in many cases it's appropriate and common for them to have different legal representatives or to act independently of each other. A common response is for an employer to say that they were unaware of and had no control over the conduct of the person alleged to be a harasser, and certainly that person needs to take independent steps to protect their position if that's what's occurred. After the complaint has been provided to each of the persons named, they'll have an opportunity to provide a response before a compulsory mediation conference occurring. A compulsory mediation generally occurs 3 or so months after the complaint has been filed and is an attempt to provide a negotiated resolution. The negotiated resolution can involve anything from payment of compensation, the provision of an apology, or any other sensible step that the parties can agree on that will bring the matter to an end. If there isn't a negotiated resolution, the matter would then proceed to a formal hearing. Before a formal hearing, there will be an opportunity for the allegations to be very clearly articulated and defences filed, and also for the preparation of written witness statements and other evidence. At the formal hearing, there will be cross-examination of all the witnesses before a judge or the tribunal will make a final decision as to whether or not the harassment occurred. In the event they find that the harassment did occur, they can order a payment of compensation or some other remedy that is appropriate in all the circumstances. It generally takes about 12 months from the commencement of the complaint to the final hearing, and then another 3 or so months for any decision to be published.